Hi, welcome back to the 360 Solicitors microcast. The album is called How the Law Works in Nigeria. This is episode 4 and it's titled Legislation in Nigeria. I'm Ishaq, a Nigerian lawyer, you can call me Shola for short. I'll be right back. Some time ago, it was reported that Nigerian lawmakers are the highest paid in the world. So the question is, what exactly is their job? Well, apart from getting paid a lot of money, one of the functions of the Nigerian lawmakers is to legislate. Legislation refers to the laws passed by lawmakers in Nigeria. These lawmakers are members of the National Assembly at the federal level and members of the state houses of assembly at the state level. Nigerian legislation is next in seniority to the Nigerian Constitution. There are 3 levels of lawmakers in Nigeria. The National Assembly is the first level of lawmakers in Nigeria. It is the equivalent of Congress in the United States of America. The Nigerian National Assembly is bicameral because it is made up of the Senate and the House of Representatives. Legislation made by the National Assembly is called an act, and a good example is the Marriage Act, which is the law that allows people to contract what we colloquially call court marriage. Actually, it's properly called statutory marriage or marriage under the Act. We will definitely talk about Nigerian marriages and the law in another album. Another example of an act is the Companies and Allied Matters Act of 2020, also known as CAMA. CAMA is the law that allows you to register and manage business names, companies and associations in Nigeria. Acts of the National Assembly can apply to the whole of Nigeria or to only the FCT Abuja, because Abuja has no House of Assembly of its own like other states. Acts of the National Assembly can also apply to an individual part of Nigeria, and the free trade zones are a good example of this. The State House of Assembly are the second level of lawmakers in Nigeria. Legislation made by the House of Assembly of a state is called a law, with a capital L. The law of a State House of Assembly can apply to the whole of the state or to a part of the state. A good example is the Tenancy Law of Lagos State 2011, which is the law that governs the landlord and tenant relationship in the state. While this law takes effect in the whole of the state, it has no effect in Apapa, Ikeja GRA, Ikoyi and Victoria Island. Note that before an act can be so called, it was a bill which the president must have signed into law. If she refuses to sign it, the National Assembly can veto her assent by repassing the bill. The situation is the same between the governor and the House of Assembly of a state. Both the National Assembly and the State House of Assembly can donate the power to make legislation to other public authorities. These public authorities are the third level of lawmakers in Nigeria. The laws made by such public authorities are called subsidiary legislation. Subsidiary legislation is important because it provides the details needed to make the principal legislation work. In this case, the principal legislation is the act of the National Assembly or the law of the State House of Assembly donating the power to make the subsidiary legislation. And that is why subsidiary legislation must not conflict with principal legislation. An example of subsidiary legislation: the National Assembly enacted the Federal Road Safety Commission Establishment Act, also known as the FRSA Act. However, the traffic rules, the dimension of number plates, road signs, among other things, are actually provided for in a piece of subsidiary legislation known as the National Road Traffic Regulations. These regulations were actually enacted by the FRSA itself. While principal legislation takes a lot of time and efforts to change or amend, subsidiary legislation does not. And that is why it makes sense to use subsidiary legislation to regulate things which need constant update in society. For example, fees, payable rent under rent control laws, technical rules and procedures, civil service rules, rules of administrative committees, rules of court, qualifications for government permits and licenses, application forms, etc. The power to make legislation is given by the Constitution. To avoid confusion as to who can make what laws, the Constitution has what is called the legislative list. These are lists of topics which the National Assembly and the State Houses of Assembly can legislate on, and there are 3 of such lists. The first is the exclusive legislative list. The exclusive list is a bunch of topics which only the National Assembly can legislate on. These include aviation, sea travels, railway, companies, intellectual property, banking, arms and ammunition, drugs and poisons, telecommunications, etc. The second is the concurrent legislative list. The concurrent list is a list of topics which both the National Assembly and the State Houses of Assembly can make laws on. For example, both the federal government and the state governments keep records. So, while the National Assembly can make laws on how to keep and access federal records, a State House of Assembly can make laws on how to keep and access the records of that state. Anything that is not on the exclusive or the concurrent list is a residual topic, which only the State Houses of Assembly can make laws on. This is the reason why Rivers State challenged the powers of the Federal Inland Revenue Service or the FIRS, a federal government agency, to collect value-added tax. Before I go, don't forget, nothing in our podcast is legal advice. Our podcast is for educational purposes only. If you need legal advice, please consult a lawyer. If you like the episode and subscribe to the channel for more, you can follow us on Twitter, Facebook and Instagram. The handle is @360solicitors or @Shola for short. See you in the next episode.